Hi everybody, it's Mike Kennedy, Vermont Bar Council. Welcome to my garage, or maybe back to my garage if you've seen one of these before. I've been doing a series of CLE by video from the garage during the pandemic. Speaking of the pandemic, I hope everybody's staying healthy, staying safe, being good to each other and good to yourselves in these trying times. I was just about to go for a run. I've got my favorite running hat on. Keeps me warm because it's cold again. I think the weather's kind of getting a pass in everything else that's going on. It's been not great out. It just started to snow and rain, kind of a mix. So I'm delaying the run to do this. My mom just actually texted me, OMG, hope you're not running right now. There's a squall with a whole bunch of exclamation points, and she's right. So anyway, it gives me a time to do this. Before I head out, I made a cup of coffee first because the garage bar is not open. That would be inappropriate. Anyway, let's get to the presentation. Today we are going to talk about fees, contingent fees, referral fees, and fee sharing. I am going to start, as I normally do, with a little pre-test, then go through the presentation. You can change your answers. Then I'll go through the answers. And then at the end, it'll end. At the end, there will be a link to a Google form that has the quiz questions. If you submit it, it requires an email address. I do that for one reason, not to see how you're doing, but it gives people who might need proof that they took the course or watched it all the way through or fast forwarded to the link. It gives you a receipt if you take the quiz that you can use if you have to prove actual participation when you report your CLEs. Anyway, here we go. So the pretest, by rule, a contingent fee agreement in Vermont. What's the answer? Is it A, it should be in writing, B, it must be in writing, C, it must be in writing and should be signed by the client, or D, it must be in a writing that is signed by the client? What is our rule here in Vermont? If you're watching from out of state, I'm not sure why you are. It's just some dude talking about Vermont's rules in his garage with a bright yellow hat on. But all the questions are based on the Vermont rules of professional conduct. Question 2, if there's no recovery, is a lawyer prohibited from charging reasonable expenses to the client? This is in a contingent fee case. Is the answer A, yes, B, no, C, no, as long as the fee agreement clearly notified the client of the expenses that will be charged to the client, even if there's no recovery, or D, that's a trick question. There's always a recovery. What's the standard here in Vermont? I'm gonna go sort of quick through this because we're gonna cover everything. And this is just a pre-test, a way really for me to sort of get warmed up into the presentation. And also, if I'm going too fast, you're watching a recording. You can hit pause or rewind. Question 3, by rule, in contingent fee cases, the lawyer's fee, when must the lawyer's fee be calculated? Is it A, must be calculated before expenses are deducted from the entire recovery? B, must be calculated after expenses are deducted from the entire recovery. C, must be used to pay the expenses. Or D, may be calculated either before or after expenses are deducted, but the fee agreement must specify when that calculation will take place. I got into that question. I was using emotive gestures. I'm really doing it just to try to stay warm. Okay, moving on. Question 4. I think there are 7, maybe 6. Contingent fees are prohibited when? In criminal cases, to secure a divorce, to secure spousal maintenance or a property settlement in lieu thereof. I like that phrase, in lieu thereof, or all the above. Oh, and it rhymes. When do we prohibit contingent fees? Rhymes, in lieu thereof, all the above. That was the rhyme. I clearly need more coffee or need to get out on this run or something. Question 5, the rule on referral fees is where? Is it in the advertising rule, the rule on fees, the communication rule, or the rule on conflicts? Where would you find the rule on referral fees? Where would a rule on fees be? Don't fall for that. That might be a fake hint because, as I've said before, the rules are not a model of clarity and are kind of confusing. Question 6, To comply with the fee sharing rule, the lawyers involved must be paid only in proportion to work done. Is that statement true or false? Ooh, la, 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 la. Question 7, client asks lawyer for representation. Lawyer has a conflict. Lawyer refers client to attorney. May lawyer share an attorney's fee? A, no. B, yes. C, yes, but only if client provides informed consent, confirmed in writing, and the conflict is one that the rules allow to be waived. So client comes to you, you've got a conflict, so you refer the client out. Can you then share in the fee? Okay, bonus question. My favorite contingent fee of all time. There's a fictional lawyer who represented Patty and Selma's nephew. The nephew got appendicitis after swallowing a jagged piece of metal that was in a cereal box. The lawyer secured a $100,000 recovery for the boy. The lawyer kept the $99,500 of it as his fee. He justified it by telling the boy that he had to pay the lawyers who had assisted with the case. In fact, they were not lawyers and they had not assisted with the case. Name the lawyer. Oh, give you a hint. Can't tell you the nephew's name. That would give it away. It's cartoon lawyer. Say that. Animated lawyer. Okay, here we go. Contingent fees in Vermont. Rule 1.5C must be in a writing that's signed by the client. There have been 2 cases in the last 10 years where lawyers were sanctioned for failing to reduce a contingent fee agreement to a writing signed by the client. In re Fink, public reprimand, which I think is the standard for the failure to reduce a contingent fee to writing. PRB decision 189 issued 4 or 5 years ago. Probably would have been a public reprimand, but if you read the decision, the lawyer had several mitigating factors in the lawyer's favor that mitigated the sanction from public reprimand down to an admonition that did not identify the lawyer. So remember, the failure to get the contingent fee agreement confirmed in writing signed by the client is a violation of the rules that has been prosecuted and has resulted in disciplinary sanctions. Okay, in the agreement, it's got to say, obviously, the method by which the fee will be determined, the lawyer's fee, and that includes the percentage that will accrue to the lawyer in the event of settlement, trial, or appeal, the litigation expenses or other expenses that will be deducted from the recovery, and whether such expenses will be deducted before or after the contingent fee is calculated. So you can do it either or, just got to specify when it will take place. Fee agreement must also notify the client of any expenses that the client will be responsible for, even if the client doesn't get a recovery. Make sure you include that in there. Upon the matter's conclusion, there are some other things the lawyer has to do in a contingent fee case as well. It kind of works, at both ends. So written agreement up front signed by the client. Then at the end, a written statement to the client showing the outcome and the amount of the fee, the amount of the recovery that goes to the client and how that was calculated. Don't forget to do that part. Okay, we prohibit contingent fee agreements in criminal cases. You cannot have a fee contingent upon securing a divorce, nor can you make a fee contingent upon the amount of spousal maintenance, support, or alimony, or property settlement in lieu thereof in a family matter. Exceptions to that rule, though. If maintenance or property is post-judgment, hasn't been paid, and someone's seeking it, you can use a contingent fee in those cases. Similarly, post-judgment child support due, someone's seeking to enforce and get child support, you can use a contingent fee there, but only if the court approves the reasonableness, because child support really should go to the kids. But the first one, past due support, post-judgment, good access to justice tool, perhaps, to use contingent fees in those cases. Often those people can't afford a lawyer. They're stuck doing it themselves. Maybe it's a way to get them some legal help and perhaps for the lawyer to get paid. Okay, referral fees. They are mentioned in the advertising rule. The rule says this: a lawyer is prohibited from giving anything of value to a person for recommending the lawyer's services. I will repeat. The rule prohibits a lawyer from giving anything of value to a person for recommending the lawyer's services. I could end right there. That's the rule. A referral fee that you give to somebody for recommending your services is something of value. It's prohibited by the rule. There are some exceptions. You can give value in the form of paying the cost of advertising. You can pay to join a not-for-profit qualified lawyer referral service. In Vermont, there's one. It's the VBA's lawyer referral service. You can pay to purchase a law practice, and you can give value in the form of a reciprocal referral agreement by giving referrals to other lawyers or non-lawyers. I want to talk about that. So these are the exceptions to the rule that prohibits lawyers from giving value, anything of value, to someone for recommending their services. The reciprocal referral agreements, they have to be non-exclusive. The other person agrees to give referrals back to you, and the client's informed. Most important, reciprocal referrals do not involve exchanging money. The comment makes that clear. We don't allow straight referral fees, okay? You can give referrals in exchange for somebody who's giving referrals for you. What about gifts? Do those count as something of value? I get that question often. Mike, can I just give somebody a really nice bottle of wine for referring me a client? I'm going to tell you what the rule says. Now, we could debate whether the rules should be changed. We could debate whether we should allow people to, give the thank you bottle of wine. Right now, the rule says you cannot give anything of value to someone for recommending your services. The bottle of wine is something of value. Now, are you going to get in trouble for that? I doubt it, but that's the rule, so be very careful. Okay, the comment also says, can't pay anything solely for the referral, okay? Unless it's in a way that's authorized by Rule 1.5E. What does that mean? So we know you can't just pay somebody for giving you referrals, but then it says, unless it's in a way authorized by a completely different rule. Well, what's that rule say? Here's what it says. It's the fee sharing rule. So you can't pay for a referral, but you can share in fees. And here's how you go about doing that. You can share in a fee with another lawyer if the fee is divided in proportion to the services that each of you perform, or if each of you assume joint responsibility for the representation. I'm going to talk about that in a minute. You can also it also requires that the client confirm in writing that the client agrees to the way the lawyers are dividing up the fee, and the overall fee must be reasonable. So here's the connection. Advertising rule says can't pay for referrals. Fee sharing rule says, however, you can share with another lawyer in a different firm if you meet those requirements. So that's how you go about complying with the rules and getting a share of the fee that another lawyer receives after being referred by you to the client. Let's talk about this. It says the division is only okay if it's in proportion to services performed or each lawyer assumes joint responsibility for the representation. So in proportion to services performed, that's pretty clear. I do 1% of the work, you do 99% of the work, I get 1% of the fee. That's how I roll work-wise, 1%. Or I can get a different percentage of the fee as long as I assume joint responsibility for the representation. What does that mean? The comment says it means financial and ethical responsibility for the representation as if the lawyers were associated in a partnership. So I refer the client to you. I agree to assume responsibility for the representation. The comment says that means I'm on the hook financially, I guess malpractice, and ethically, as if I'm actually representing the client, even though you're doing the work. Basically, joint responsibility is joint representation. Now, I'm not the only one who thinks that. In 2016, the ABA issued formal advisory opinion 474. It's on referral fees and conflicts of interest. Here's what they said. This is talking about what does it mean to accept joint responsibility for a representation in such a way so as I can then share in the fee. It means this: a lawyer who refers a matter out, okay, has essentially undertaken the representation of the client. Joint responsibility equals joint representation. I'll read it to you. A lawyer who refers a matter to another lawyer outside of the first lawyer's firm and who divides a fee from the matter with the lawyer to whom the matter has been referred has undertaken representation of the client. This is interpreting ABA Model Rule 1.5e, which is exactly the same as the Vermont rule. People find that to be pretty strict. Well, wait a minute. I referred it out. How have I possibly undertaken the representation? I'm going to share with you some language from the comments to the District of Columbia Rules of Professional Conduct that walk through it and reinforce the message I'm trying to convey. The concept of joint responsibility, having made a referral, is not merely a technicality or an incantation. A referring lawyer remains fully responsible to the client and is accountable to the client for deficiencies in the discharge of the representation by the lawyer who has been brought in. Okay? So again, I'm going over these to remind you. If you want to share in the fee, you want to do so by, oh yeah, I'll assume joint responsibility for the representation, which is what the rule says. This is what it means. It means you're responsible to the client, accountable to the client for any deficiencies in the representation provided by the other lawyer. If you don't want to do that, this is what the comment says. If a lawyer wishes to avoid such a responsibility for the potential deficiencies of the other lawyer, the matter must be referred to the lawyer then without retaining the right to participate in fee sharing beyond those fees justified by services actually rendered. So if you're going to refer it out, you're not going to do any work, and you don't want to be on the hook for anything that the other lawyer does wrong, you can't share in the fee. That's what that means, okay? Now, you refer it out. Does that mean you have to be watching over the other lawyer's shoulder 24/7? No. Here's what the comment to the DC rule says. It's also consistent with the ABA opinion. The referring lawyer may agree that the lawyer to whom the matter has been referred will do all the work without any review by the referring lawyer. Thus, the referring lawyer is not required to, for instance, review pleadings or other documents, to attend hearings or depositions, or otherwise to participate in a significant and continuing manner, okay? However, the referring lawyer does not escape the implications of joint responsibility by avoiding direct participation. So the upshot is this, and I've struggled to sort of articulate it. I'll try to do my best. You refer a client out, you want to share in the fee. Either you get paid in proportion to the work that you did, or you assume joint responsibility for the representation. And that's more than just saying, yeah, I assume joint responsibility. It means you're on the hook. So be careful about who you are referring clients to. Now, when you have a conflict, when the basis for the referral is, I've got a conflict of interest. Some referrals happen because, well, I don't really do that area of the law, but I'll refer you to somebody who does. Other referrals happen when client comes in, I've got a conflict of interest, I have to refer you to another lawyer. Remember, here's what the ABA opinion says, and this is because, remember, the referral is joint responsibility, joint representation. Well, you've got a conflict. So unless the client gives informed consent, confirmed in writing, the lawyer who's got the conflict can't share in the fee. So basically, when you refer it out due to a conflict and you want to share in the fee, it's got to be, you've got to have informed consent from the client who you're referring away. You explain the conflict, and it's going to be the type of conflict that we would allow you to waive, okay? Otherwise, you can't share in the fee, and that comes straight from the ABA's formal opinion. Remember, little tip here. When you're sharing in a fee with a lawyer in a different firm, the client has to confirm in writing that the client agrees to the fee division. Do that up front. Don't do it at the end afterwards to sort of cover yourself. Here's what the ABA opinion says. The agreement should not be entered into toward the end of the relationship. Once you've done all the work for the client who got referred to you, the fee agreement, the client's agreement to the division of fees must be agreed to either before or within a reasonable time after commencing the representation. Okay, so let's go through the answers. Touched on them all, I think. In Vermont, contingent fee agreement must be in a writing that's signed by the client. If there's no recovery in a contingent fee case, is the lawyer prohibited from charging expenses to the client? No, as long as the fee agreement clearly notified the client that that would happen. Now, a lot of lawyers eat the fee or the expenses if there's no recovery. That's fine. The rule authorizes you to pass them on to the client, though, as long as you tell the client up front in that agreement that the client has signed in writing that that's what's going to happen. Lawyer's fee can be calculated either before or after expenses are deducted. The fee agreement has to say when the calculation will take place, and then obviously when you go about doing the calculation, abide by the terms of the fee agreement. Question 4, contingent fee agreements are prohibited in each of those types of cases. Question 5, the referral fee rule is in the advertising rule. It's false. That is not the only way to get paid to share a fee, meaning we talked about it, if you assume joint responsibility for the representation, you can also share in a fee. The fact that getting paid only in proportion to work done is not the only way that can happen. Question 7, you refer a case out due to a conflict. Can you share in the fee? Yes, if the client provides informed consent, confirmed in writing, and the conflict is one that the rules allow to be waived. And the bonus question in this case, but it told you that Patty and Selma's nephew's name is Bart, you would have known most likely that it's Lionel Hutz and Elizabeth Kruska, incoming president of Vermont Bar Association. She sent me that business card from Lionel Hutz. I'd forgotten about that from the show. It just makes me laugh. So thanks, Elizabeth, for sending that on and helping this little seminar out. Anyway, that's it. Any questions on contingent fees or referral fees or fee sharing, give me a call. I'll try to help talk you through it. Here's the link if anybody needs to take the quiz to have proof that you did. There's my email address if you want this presentation sent to you or if you have a question you want to ask. Anyway, thanks for listening. Probably not the most thrilling topic to discuss, but there are rules on it and the rules are good to abide by. Now the squall has stopped. It's not raining or snowing, so I'm gonna get out there and go for a run. I hope everybody has a great day. Take care.